Nick Brown and Greg Long on behalf of the sponsors.
Morning, Your Honor. I'm Steve Fogg with the Court Cronin firm in Seattle, here with Eric Lindbergh, and we're here on behalf of the NRA.
Glenn Morgan, here pro se.
Joe Wilson, pro se.
Thank you very much. So I don't know if this is Ms. Igler's issue, but I wanted to address first, before we move forward at all, this court's hearing of the matter. And there seemed to be a question of a notice of disqualification, so I wanted to address that preliminarily. Ms. Igler, do you have another issue?
I do, Your Honor.
Okay. I don't know what your issue is, but do you mind if I address this issue first?
Certainly.
Okay. So I will tell the parties that it appears that the procedural matter of the notice of disqualification was handled in a rather peculiar manner by the court. And I apologize for that, but it has to do with some correspondence with Mr. Morgan. I don't know whether all of the parties were aware of this, but there was a notice of disqualification filed in this case. And then it was court staff's understanding that Mr. Morgan, who filed that notice of disqualification, withdrew it or attempted to rescind it. So first I'll ask Mr. Morgan, was that your intention?
Your Honor, I had been made aware of how many other parties were involved in this case, and it became concerning to me, even though that was my intention, that I was going to affect a lot of other people beyond just my situation. And that was when I contacted the clerk and indicated that I would be willing to rescind it, except there's really no process set up under court rules that I can see to rescind it. So I just simply had sent them an email at that time. I did think I had notified everybody at that time, but if I had failed to do so, I apologize for that.
So that is your intention?
That is my intention.
Excellent.
Yes. Yeah, thank you. Okay. Unless you had any other questions yet, Your Honor.
Okay. So as a result of that, it appears that between the clerk's office and Superior Court, the matter was not reassigned to a different judge because of the court's understanding that that had been rescinded. Personally, I would expect a pleading to be filed to indicate that, because a pleading was filed to show a notice of disqualification. So that would be my expectation, but this is quite an unusual circumstance. So I just wanted to bring that to the party's attention. It appeared to me, although I'm not certain, that all of the parties were aware of this and were all given the opportunity to file a notice of disqualification if they wished. But I just wanted to make sure of that, and I would like to hear from the parties to make sure that they're not concerned about this court hearing the matter.
Your Honor, first, we're not concerned at all, and we're happy to have you here on that. Thanks. And we were aware of the back and forth, so this is not news to us.
The same for the sponsor, Your Honor. Mr. Morgan did let us know that he had filed the notice. We didn't see it after the briefing, but he had made the parties aware. We have no problem with the court hearing.
And the state as well was aware of Mr. Morgan's correspondence and the initial pleading, and we have no objection.
And I have no objection at all.
Thank you very much. With that out of the way, Ms. Ziegler, I'll hear from you next.
Your Honor, I have an oral motion to make to strike the brief of the NRA. The order from this court was that reply briefs be filed by noon yesterday. The NRA did not file their reply brief with the Attorney General's office. And this is particularly concerning because the Attorney General's office has gone to great lengths to be cooperative with the NRA. Their initial complaint in this matter was not timely served on the Attorney General's office. We received it a day late, and we chose not to take any action with regard to that late filing. We then entered an agreement to receive service by email to make service easier, and yet still, we did not receive that reply brief. And for that reason, we ask that it be stricken.
Good morning, Your Honor. It's true. I apologize. It was an oversight by my office. We did not. We served the other parties. Of course, we served the court, but it was an oversight on our part. It's our error, and we defer to the court, but it certainly was nothing personal with the AG's office. I don't want to get into that. We think we disagree with them on the service issue of the initial petition, but this was just a pure oversight by my office.
So all other parties were served other than the Attorney General's office?
Correct.
ma'am.
Yes, correct. So it was just, I mean, it was again, no disrespect to Ms. Ziegler, no disrespect to the AG's office. It was just a clerical error within our office that Ms. Ziegler brought to our attention this morning. We apologized for it. I assume that she has had access to our brief, but that said, I mean, it is true what she says that we did not get it to her yesterday as we should have.
Does anyone else wish to be heard on this matter? Ms. Ziegler, anything else?
Nothing further, Your Honor.
The court at this time is denying the motion to strike. I will say that, as many of the folks here know, the court has worked fairly hard to try to make this process one in which all parties have the opportunity to provide briefing and that the matters are heard on an expedited basis. That requires the cooperation of law firms that typically do this kind of work, pro se folks that represent themselves and may not be familiar with the court, as well as the Attorney General's office. And we've tried to develop a procedure that is transparent, that allows everyone to follow it, but also allows an expedited process, and it requires the cooperation of everyone. It's unfortunate that that was not followed in this case. I accept the statement that that was an oversight and an error. It is unfortunate in an expedited case like this that such an error occurs, but I know from the court's perspective that court staff sometimes make errors in very important expedited cases as well. It's not intentional. I suspect that that's the case here as well. I hope that the parties will endeavor to not have these kinds of errors in the future, but I'm hopeful that the parties have had adequate time to look at that brief. The court has reviewed it, and so I am prepared to go forward considering the brief, but I appreciate being notified of this issue. It's not my expectation that this kind of practice occur. So with that, I would like to proceed hearing from the parties regarding this ballot title. The court has reviewed all of the briefing that's been provided, and I appreciate the suggestions of all of the parties as well as the Attorney General's office in working to formulate a ballot title in this case. So I think what I would like to do is hear from the challengers first before I hear from the Attorney General's office, if that's okay.
Yes, Your Honor, it sounds like a good way to proceed.
Okay. And so I don't know if the parties have spoken in terms of order or if there's an
We have
issue.
not. We were hoping you would bring light to that darkness.
And Your Honor, if it's easier, the sponsors are happy to go first.
I'm sorry,
If it's easier, I'm happy to go first.
that's fine with me.
Okay, 5 plus 2.
You may proceed, Mr. Brown.
Thank you, Your Honor. Good morning. Initiative 1639 was created to reduce firearm violence and improve the safety in our communities. And no matter people's political perspectives or policy perspectives, I think this is an issue that everyone can agree on is important and critical to address. So the initiative attempts to tackle these issues in a couple different ways. First, it creates new requirements that relate exclusively to the purchase and transfer of semi-automatic assault rifles. And it does this by requiring enhanced background checks, by requiring new age limits, and requiring safety training and waiting periods. And second, the initiative enacts new requirements that apply to all firearms. And most importantly here, it creates secure storage requirements that applies to all firearms. It's also important to highlight a couple of things that the initiative does not do. The initiative does not change any of the requirements relating to the purchase or transfer of pistols or any other firearms, and it does not create a new tax. So given these impacts, and given the text of the measure itself, the question before this court is how, with limited words, do we fairly and accurately and impartially convey to the voters what the text of the measure does? So with those guidelines, the statement of subject has to be sufficiently broad to reflect the subject matter, as well as being sufficiently precise to give voters notice of what the subject is. And the concise description must be a true and impartial description of the measure's essential context, clearly identify for voters the propositions they're to consider, and be crafted in a way that does not create prejudice one way or the other. And these goals are set forth in the statute that the court is well aware of. So the essential goal for the court is to give notice to the inquiring voter. What do I need to look for when I see the ballot title language? What do I need to be aware of? The court's task is to create an accurate and fair title. And importantly, in this proceeding, we're only looking at the measure itself. We're not considering the merits of the measure. We're not considering the constitutionality of the measure. We're not considering its impacts, but only what does the measure do. In that regard, the sponsors want to highlight a few areas where we agree with the language that was proposed by the Attorney General's office. Beginning with the statement of subject, we agree that firearms is the appropriate word to use there. It is both sufficiently broad to reflect the title and the subject, and sufficiently precise. And the other challengers have criticized the use of the term firearms, but I just want to say that the initiative does a bunch of different things with respect to firearms legislation. It tackles a number of different provisions of existing law. So it has to be broad enough to accurately reflect those different areas. But firearms in and of itself is a very specific and precise terms. In all the universe of items that might be on a ballot any given election year, this draws voters' attentions to a very narrow, specific topic of the law that is being proposed to change. So firearms is appropriate there. The other words that have been suggested by the other petitioners fail the statutory mandate. Some of the petitioners have suggested restrictions on firearms. Another petitioner has suggested taxation language be included in the statement of subject. But those fail being broad enough to give notice of the subject and to be precise enough. And they're not sufficiently inclusive of all the various things that the ballot measure attempts to do. With respect to the concise description, we again agree with most of the language, but we do have a few issues to address. First, as I stated earlier, the initiative that the sponsors drafted here does not affect the purchase and transfer of any other firearms other than semi-automatic assault rifles. Section 13.1 is very specific in dealing only with creating new provisions with respect to semi-automatic assault rifles. Second, this term, semi-automatic assault rifles, we believe is perfectly appropriate here. It's a commonly used term. It's a term that's been used in federal law for over 20 years. It's a term that's been used in Washington courts for some time. It's a term that the public is generally familiar with. And again, what we should be focused on here is giving the public a heads up about what type of weapons, what type of firearms we're dealing with. And we believe when the voters see semi-automatic assault rifles, they're going to know specifically the types of weapons that are used here. And the alternatives that have been proposed by the petitioners, the other petitioners, fail. One of the petitioners suggested semi-automatic firearms, which does not cover all the types of weapons, the narrow type of weapon that is addressed here. As we put in our brief, there are actually a number of different types of semi-automatic firearms. They can be handguns or shotguns, and so that definition is not accurate. Another petitioner suggested certain firearms. Certain firearms doesn't give voters proper notice about the types of weapons that are at issue here. Third, in the concise description, we also agree with the use of the term enhanced. We believe that it accurately describes the type of background check that is in play here. Again, this is also a commonly understood term. It is used elsewhere in Washington law. We think the example of enhanced driver's license is actually a good example for the court to be familiar with. That is a term talking about a license that requires an additional or an increased background check. And it's one that voters and the public in Washington are familiar with. And the term enhanced meets the Webster's dictionary definition. We don't see any reason to change that to some of the other suggestions by the parties. And-
Mr. Brown?
Yes.
What do you see as the difference between the proposed additional as opposed to enhanced?
You know, there's some minor different connotations. We do prefer enhanced. Certainly if the court was inclined to look at alternatives to that, we would suggest increase rather than additional. They do have some connotations, but I think that the way that the other petitioners have framed it as implying some superior or better improved is simply not accurate. Again, if you look at enhanced driver's license, I don't think people think that you have a better driver's license. They just recognize that you have additional background checks that came with that. So our preference would be to use enhanced, as was adopted by the Attorney General's office. If the court was looking for an alternative, increase would be our next suggestion. They are similar in connotation, but we disagree with the way that it's been framed by the other petitioners. And then lastly, the catch-all phrase that the Attorney General suggested for firearm safety requirements, we do think that given the limited words that are available here for the court to play with to come up with the right language, that accurately encompasses the other provisions of the bill. Obviously, we can't list every specific detail that's in the initiative, and so generalizing those firearm safety requirements meets that standard.
Mr. Brown, my apologies.
Oh, no problem.
I have a question about that phrase. And the other parties might react to my suggestion as well. Again, this isn't my ruling, I'm just throwing this out. Given that, for reasons that the parties have already briefed, the public should understand that this initiative is about something about firearms. Is the firearm safety phrase necessary at all?
As opposed to just other requirements?
Yes.
I think the court raises a good point that the voters are going to know this is all about firearms and issues related to firearms, and specifically, primarily, semi-automatic assault rifles. Other requirements might not provide enough direction to voters about what other issues we're going to be talking about here. The initiative does focus on firearm safety measures, warnings that give safety warnings, and those sorts of provisions. If the court was looking for additional space and wanted to strike words, we would understand that. That might be appropriate. But I do think that giving voters as much specific notice would be appropriate here.
Thank you.
As we laid out in our brief, one of our primary concerns with the AG's language is the term towards the end of the concise description, criminalize certain storage and authorized use. And we recognize there's a lot of different ways you could capture the secure storage firearm provisions that are in the initiative, and the parties have all suggested different ways to do that. Our primary concern is sort of twofold. One, the term certain storage really, to us, does not convey any level of specificity. Certain storage is vague, can be kind of misleading. And then second, the phrasing of criminalize certain storage and unauthorized use is simply inaccurate. There's nothing in the initiative that criminalizes the unauthorized use of firearms. What it does is has criminal provisions that stem from the failure to use secure storage provisions in certain circumstances. Our suggested language was really to try to give voters, firearm owners, people who have weapons in their home, what are we required to do? What is this law going to change in my behavior? And that's why we suggested that require secure storage that prevents unauthorized use would be the best way to capture that. That really frames the change in behavior that's going to be required of firearm owners or people who have firearms in their homes, and that was our suggestion. We did suggest an alternative in our brief that we filed yesterday. If the court was inclined to use the word criminalize, we would accept that, but we do think it still has to be accurate. And so if the court is inclined to use criminalize, it should be criminalize that results in unauthorized use. And so our suggestion would be to use criminalize unsecured storage resulting in unauthorized use. Again, we would prefer the require language, but we do want to make sure that what we're really talking about here is the unsecured storage that results in some unauthorized use and not simply the unauthorized use itself.
Mr. Brown, with regard to that, I've thought quite a bit about that phrase, even before seeing the suggestion in your most recent brief. And I have a couple of thoughts on that I wanted to run by you. I understand your suggestion. I'm concerned that it has too many words, given other things in the, that we have to capture in the concise description. But I appreciate the suggestion. And one of the things that I was thinking about is a phrase of criminalize certain, criminalize certain unsecure storage upon unauthorized use. And I know that doesn't quite capture everything, but I was thinking about a way to address the concern that you and others have raised that the current description may not put the two together. In other words, unsecure might not be the right word, but unsecure storage combined with unauthorized use.
And how did you phrase the last portion of that?
Upon unauthorized use.
I mean, I guess there's some small semantic differences there. We did, in looking at a way to potentially save words, so our original suggestion in our alternative was unsecured storage that results in unauthorized use. We think the court, if it was inclined to look for more space, could say criminalize unsecured storage resulting in unauthorized use. That would save one word there. I guess my preference would be for the way that we propose, as opposed to the court's alternative. I think they capture generally the same sort of idea.
Or after unauthorized use. Again, only one word.
Yeah, I don't think it's a tremendous difference. Next, Your Honor, a number of the other petitioners have raised in various forms this dispute about whether the initiative creates taxes or whether it creates fees. And so I want to spend just a brief amount of time on that. First, again, the court needs to be concerned not with the merits of this initiative, only what the language suggests and how do voters interpret that, and therefore how do we capture that in the ballot title language. And here, the Supreme Court in Washington has made clear that the dispute between taxes or fees is really not important. When the court was addressing Initiative 1183 not too long ago, the court said specifically that the proper inquiry is not on the legal distinction between taxes and fees, but instead on the language that the initiative as the average informed voter would have read it. And here, the average informed voter is going to look at the initiative and see that the Department of Licensing has the option of creating an administrative fee that comes with the purchase of weapons, no matter how many weapons are being bought at any given transaction. And second, the fee is really a minor portion of this initiative. We didn't think it was necessary to capture it at all, really, in the description. There's obviously a number of various provisions here. An administrative fee that the Department of Licensing may enact is really not what is critical. It's not what we think voters are going to be most concerned about. Again, if you wanted to use other initiatives or other ideas and examples, you could imagine if we were going to pass a enhanced driver's license initiative, if they didn't exist. And that initiative would have all various sorts of language describing the procedures and the background checks that were required, and that would also have this driver's license is going to cost $25 more. That would really be a minor part of that overall initiative. And similarly here, we think that the $25 administrative fee that might be imposed is really what's not going to be driving voters' concerns in terms of addressing and considering whether to support this initiative. But we certainly don't think it is properly characterized as a tax, and we don't think that that's really a decision for the court. It should really reflect the language in the initiative. Turning to the ballot measure summary, Your Honor, just to conclude, again, there's a number of similar issues that we have previously addressed. The same issues regarding the age limitations. Again, we want to make sure that that language is clear, that it only affects a change in the law with respect to semi-automatic assault rifles. We did prefer condensing some of the language regarding the secure gun storage provisions, which is why we suggested secure gun storage /devices. We think that /devices would give voters some awareness of this measure affecting trigger locks. If we had all the words to work with, then we would have no problem with that additional language as the AG has suggested, but we do think that summary or that condensed version addresses all of those provisions. And then lastly, on the summary, we did propose 3 minor tweaks. They are minor, but we do think they're important. We suggested safety training rather than firearm training. Again, primarily because firearm training might convey to your average voter that this initiative is requiring some sort of proficiency training with firearms. And maybe it's the ex-military person in me, but that's what I read when I first read firearm training. But the initiative specifically deals with safety training and making sure that the handlers of firearms are safely proceeding when they use firearms. So we think that that one word switch would actually be an improvement in clarity here. We also...
My apologies. Would that also cover the initiative's requirement of basically training in the law? Because that's part of the training requirement as well, correct?
Sure, yeah.
I just am curious if you believe that's broad enough to cover that. I understand your argument with regard to firearms training, but I question whether safety training is broad enough to include all of the required elements of that training.
Well, I think that, one, so voters are going to know this all deals with firearms, right? So the word firearms from our perspective is not necessary here. Safety training, we think, encompasses the primary aspects of the training that's required. And all of the laws that deal with firearm regulations are all geared towards the safe usage of firearms. There's not a provision dealing with firearms that really is not aimed at making sure that firearms are safely used and safely stored and safely handled.
Well, to just respond to that, certainly others may feel like the age limitations alone are not necessarily related to the other provisions about storage and that sort of thing. So they are, they could be characterized as different kinds of training subjects as opposed to just safety.
Well, I certainly think they're different kinds, but in my understanding would fall under the umbrella of a safety measure. Obviously, we disagree about the merits of that, but we're not here to debate the merits. But the initiative language specifically addresses increasing the age requirements to make it more safe to use, to reduce violence, in particular among young people. And so, under the umbrella of safety trainings, and again, we can't specify with all the words in the world here, but under the large umbrella of safety training, we think that that fairly captures that. And then lastly, we suggested adding administrative fees rather than just fees. Again, we think that because there is space here with the words, that adding administrative fees accurately reflects what the initiative language proposes. This is an administrative fee that is used specifically to address the increased costs that the state or local officials might have to do these additional background checks for semi-automatic assault rifles. It is not a general fee, it is a fee specifically for that administrative purpose, and we think that provides the voters with more clarity. But lastly, Your Honor, we do think that if the court is inclined to accept our proposals, that it will provide more clarity for the voters and that they'll know best how to proceed when they're considering this matter.
One last question,
Yeah, sure.
and it pertains to the word limitation as opposed to restriction regarding the age. And help me understand your position with regard to a change in that language.
Yeah, as we noted in our brief, our preference would be on age restriction versus age limitation. And it's just a small difference in connotation. I think the average voter, when they hear the word limitations, they think maximum. So age limitation might convey that you can only possess or own firearms up to a certain age, which is obviously not the case in any law regarding firearms. Age restrictions will tell the average voter that there are restrictions on use, and it doesn't necessarily convey that there's a minimum or maximum. We certainly played around with that language. I understand from the AG's brief that they don't have any strong objections one way or the other, but we do think that restrictions is a more accurate and precise term. Again, it's a small difference, but limitations might convey something different.
So outside of the briefing of the parties, I'm just thinking about those two words, and it seems like restriction may be more broad to imply something less of a bright line, whereas limitation is more of a bright line. And it seems like the age requirements in the initiative are a bright line, so limitation might more appropriately apply.
I understand that argument. I mean, to me, restrict in a law is pretty clear. But we did consider a number of alternatives, age minimums, was another word that we talked about as maybe being an appropriate alternative. That might convey precisely that there's an age minimum requirement for which people can possess these type of weapons. Again, I just think that limitations has a connotation that conveys a maximum rather than a minimum, which is why we suggest restrictions.
Thank you.
Thank you.
Good morning, Your Honor. And Steve Fogg here on behalf of the NRA. I do appreciate you hearing this on an expedited basis, and I'm very aware that you're steeped in the brief, so I'm not going to spend a lot of time on each point in the brief. I really have about 5 key points that I wanted to talk about in particular, and then obviously if the court has any questions, I'd be happy to entertain those. I largely agree with Mr. Brown in terms of the context he laid out here in the middle, here at the beginning. We're not here on the merits. We're here, I think we're all here working in sort of a inspiring way to get objective notice out to the voters, right, to what is important for them. And I think the key, and I can sort of hear the theme developing just from the court's remarks so far, is that, we're trying to avoid value judgments, right? Like we're trying to avoid any sort of foreshadowing what we think is important. We're just trying to lay the facts out as objectively as we can so the voters can decide. And so the points that I'm here to make, I think largely sort of fall into concerns that we have about value judgments that may be loaded into certain words. So I just want to let you know that's sort of where I'm going. I'm going to begin with the statement of subject. And as everyone has said so far, and I think it's true, it has to be both broad and precise, which could be a hard thing to do, right? This is certainly broad, saying that and we have 10 words. Saying that the statement of subject is about firearms, that's certainly broad enough, but we don't think it's precise enough. I don't think there can be any reasonable argument that this initiative, whether you're for it or against it, it's about restrictions and limitations on firearms. That's what it's about. And they think it's a good idea. We think it's a bad idea. We're not here to debate that. Okay, but the fact is, what this initiative is about restrictions on firearms. So we think it is important for that to be in the title, and it's simply not sufficient to say, well, it's about firearms. It's about more than just firearms, right? It's about restrictions on firearms, and that's certainly been the way other initiatives have had similar titles. So we think that that's an important thing for the court to consider. In terms of the concise statement, I have 5 points that I wanted to make on that. Number one, we do think and are very strongly opposed to the use of enhanced. And I think that gets at exactly what we're talking about. I mean, enhanced is a value judgment. And you can look at Webster's and say, well, no, enhanced doesn't necessarily mean better. But I think most people, when they hear about something being enhanced, they think it's an improvement, right? I mean, like that is I think a understandable connotation of enhanced is it's an improvement. And even increased, it is less concerning to us than enhanced, which I think is just a flat out, there is a value judgment that's loaded into that word. But even increased, people think increased, that's better. We think additional is the most objective, scientific way to describe what is happening. And we think it is in keeping with the process that we really have here, which is that we want to avoid value judgments.
I have a question about
Sure.
that. Isn't enhanced the language in the initiative itself? And that's language that was used, and also it appears that the background checks are a little bit different, not necessarily, it's not necessarily just additional, but sort of different quality, not necessarily, not better or worse, but different. Is I guess how I would characterize it. So
I hear what you're saying. The fact that it's in the initiative, I don't think it should control, because that would subvert this entire process. You could just load these value judgment terms into your initiative and say, well, it's in the initiative. So I don't think that should control. But I do think and I hear what we only have these words to play with. An additional does capture what is actually happening. And you're right, you could look into the initiative with more rigor and find that, well, there are other things going on than additional. But additional, I think, is the broadest, most judgment-free way to capture what is being proposed by this initiative. And that's all that we're looking for. The second point we would make about the training, we think it's important for the voters to know that this is new training. Like, this is, again, additional training. This is training that hasn't been suggested or hasn't been imposed in the past. We think it's important for the voters to know that this is something that would be new. And again, we only have 30 words, but we're looking at what can we say to, what would, if you're a voter and you're taking whatever it is, however it takes to read 30 words, 1 minute, what would be important? And we think of not just the fact that it's training, but that this is something new.
Isn't that true of every aspect? In other words, you could put new background checks, new criminalizing, everything is new.
Well, I don't know about that because, I mean, background checks are not new, right? I mean, we have background checks.
But not these.
But not these, but this, I guess that's why I would say new for the training, right? This is something brand new, right? Like new in terms of like a category, right? Not an increase or enhancement to a category. This is something that is new to, that there hasn't come before. So we just think it's important to sort of signal that, like, this is something, this is an added complement to what has existed in the past.
The criminal sanctions, though, are new.
That's true, although, I mean, if we're really going to get into, I mean, there are other criminal, it's not like, I mean, there are aspects of firearms regulation that have been criminalized in the past, right? I mean, what we're saying is, like, this is really something that hasn't been done at all like this before. On the third point I want to make is about sort of the criminalizing, to your point about criminalizing firearms storage. You know, it's a good example of how I think the way the briefing process should work. I think as we reviewed the briefing, we were sort of persuaded that I think our proposed language about mandating firearm storage, I think that would fall prey to what I've been criticizing things. I mean, I think that there's a value judgment in that. So we would back away from that suggested language. What we think is important, like frankly what the AG finds is important, is we do think it's absolutely critical that the voters know that there's conduct that is being criminalized. So, and in fact, the language that Your Honor was, I don't know if you were just ad-libbing that with Mr. Brown, but the language about like upon use or after use, I mean, as long as the language comes through to the voter that this is conduct that is being criminalized, that's what's important to us. So I just wanted to let the court know we're not dead set on mandate, and in fact, we could understand an argument that, you know, you're putting a value judgment, but we do think it's important that the voters know that there's going to be a criminalization here. The purchase fees, I think that's absolutely critical to being a 30-word thing, and I was, I guess as a political observer, I was amused that when Mr. Brown said, "Oh, that's a minor thing," that, you know, the voters wouldn't care so much about these fees. I mean, voters, that's right? I mean, like taxes, fees, however, I mean, that is a crucial aspect of a voter's decision, you know, the pocketbook. What is this going to cost me? That's important. You know, whether you agree with it or not, whatever your position is on taxes, whatever your position is on purchase fees, the fact that a fee is going to be imposed is something that I think would be top of the list for most voters when they just want to know, well, what is this thing all about? So we don't think it should be just sort of pushed into a catch-all. The fact that, and we don't, you know, we're not saying that it would be characterized as a tax. We're not taking a position on that. What we're saying that voters absolutely should know from this concise statement that there is a fee that is going to be part of this initiative.
Mr. Vaughn, with regard to that, do you have a proposal with regard to adding reference to fees that is limited in words, because we have almost no words to work with here, and that also captures the fact that the initiative itself doesn't impose those fees necessarily, And then also captures the fact that the fees are not just authorized for purchase, but also transfer.
Well, for the concise statement, we feel like the transfer doesn't matter much, right? Because most of the time it will be about purchase. And maybe it's to live, but our view was like, come on, you have to be kidding me. Like, if they say that they can impose the fee, they're going to impose the fee. So sort of getting hung up on, well, they don't have to impose it. It's just permit, we know that the fee is going to be imposed. But I guess if the court thinks that that's important, I guess what we could do we could say impose age limitations and permit purchase fees, or allow for purchase fees. To me, that seems like a nuance that would not be necessary in the concise description, because we think it is a certainty that if this passes and survives challenges, that it would be, the fees going to be imposed, and I think that's what a voter would think. But I think that you could add a word or two in there if you want to get that. As I said, I don't think that for the concise description, we'd be much less concerned about sweeping in transfers. I think our concern is the purchase. But you could, I think, get a word or two in there that would suggest that it's not a requirement that it be imposed, it just would allow it to be imposed. And then the fifth thing, and then that's really all I have to say, is we do think the fact that posted warnings are going to be required again in the 30 words that we have. We think that's an important thing to a voter. If a voter's looking at this and trying to figure out, well, what is going to change about this, that's something that's a little bit different from the other aspects of this that we think are important. And we think, I really don't think our view is like if you have 30 words, there's not really ever a place for a catch-all, right? You should use the 30 words to be as specific as you can about what the most important 30 words are about this initiative. So for us, the fact that warnings are going to be required to be posted, we think that that's, again, we're not saying whether you think it's good or bad, we think the voters should know about that. That's all we had made some comments about the measure summary, but those are in our brief, and I think they largely track what I've just said. So unless the court has any questions, that's all I have. I appreciate your time.
Thank you.
Thanks.
Mr. Martin.
For the record, my name is Glenn Morgan. I'm here and I'm representing myself pro se as one of the petitioners challenging the ballot title. And I think that without repeating what you've already read in the briefs, I just wanted to kind of give an overall summary. It's very important that the ballot title be accurately representing the contents of what the actual initiative does, especially significant and major issues that are introduced to the public and new in this initiative. And we're not here to argue, obviously, the merits of the initiative, just simply what the language that's being presented during the statement of subject and the concise summary in particular is what I wanted to focus on initially, is whether they're accurately representing to the average educated voter what this initiative actually is, so they know what they're voting and what they're signing. And I've broken down my oral arguments into basically two categories of concerns over this ballot title. And first, I'm going to call it like a sins of omission, meaning that what's not adequately communicated at all to the voters in the title. And secondly, sins of bias, which would be language that's used that's not fair or impartial and contains value-laden terms that create bias for the voter. And I think there are two, to me, there seems to be two particular things that are introduced with this ballot title in the contents of the initiative that's being proposed here that aren't adequately represented in the statement, certainly the statement of subject, the concise summary. The most important one, I think, is this introduction of a new felony level crime. We're attempting to there's been a lot of concern about over-criminalization in the court system in general. And we're adding a whole new category of crime, in particular, I think, in a way that most people will not realize is a crime, and that people can be convicted as a felon because somebody broke into their house 10 years ago and stole a firearm and then committed a crime at some point in time in the future. There's no, within with that firearm, there's nothing in this initiative that puts a time limit on that or really clarifies exactly what safe storage actually means. And we don't.
But Mr. Morgan, there
Yeah.
are limitations in the initiative itself that certain activities can't be prosecuted, and I'm not sure.
Very unclear though, and this is what it's the question is then, when something, if it's, for instance, if your car is stolen and it's gone, it's committed a crime, usually you don't charge the person who had the vehicle stolen with the felony. If somebody breaks into your house and steals pharmaceuticals and then commits, a crime with those, they don't tend to charge people who had the drugs as if they were legal pharmaceuticals with a crime, usually. And what this is introducing is a very new, you're already a victim of a crime, and now you're going to become you're going to become a criminal yourself because of what may or may not be done with what was stolen.
So I completely understand what you're saying.
Yeah.
But my reading of the initiative language is that there are certain exceptions that includes, and I don't have the language memorized, but there's an exception for a person who is a victim of a crime who, within 5 days of knowing that the firearm was stolen, reports it. Is that your understanding?
The way that it's written, it looks like that if it's reported, so if they know within 5 days, right? And if that storage was then determined to be adequate. And that is not very well defined in this initiative, what safe storage, what adequate storage really means. If my house is locked up and it's difficult to get into my home, is that adequate storage for what I contain within the home? There is no clear definition at all in this initiative. So that, I think, to the average voter, they're not going to have the significance of that. And the many people who will be charged potentially under this initiative before this court and others who become as felons, who clearly have committed no crime, then I think that this is a big change. Whether, again, not the merits, I guess we're not arguing about them, but this is a big change in that this initiative introduces, and it's very much glossed over, I believe, in the current concise statement and summary that's been presented.
So I think I understand your point. So let me ask you this. As you can tell, I'm working with this language here.
Sure.
And to pick up on some language that you suggested with regard to the criminal components, would it be adequate to you if the modification to the concise description were as follows: criminalize non-compliant storage upon unauthorized use?
I think that would be better than what currently exists, Your Honor. The other question I had, and the reason why my proposed concise statement put that first, is I felt that that was introducing this whole new idea of being able to be criminalized for an activity, putting that first in the concise statement, because it's a fairly significant, it's a big deal for the average voter to know. And so that was why when I provided my concise statement, I put that at the top. And I realize there's not necessarily a requirement in the statute that things be done in a certain order, but logic would dictate that the most significant elements of an initiative, one would think should be in early, and then the less significant should be further on down. At least that's my argument that I would make here. The second element of that I think is still also pretty significant is this gradual, this denial of constitutional rights and effectively civil rights under both the federal Second Amendment, to the Constitution, to citizens who are 18 to 21 years of age, and also under the Washington State Constitution, which is Article 1, Section 24, which addresses the same issue. And these are civil rights, and they are being restricted and under this initiative, and it needs to really be clear that that's what's being done. The age of majority is 18. People can join the military, they can vote, they can sign legal contracts, they can get married, they can run for political office, arguably doing more damage in those areas than they would having the ability to actually possess commonly found firearms for self-defense or other reasons. And again, not arguing about the merits of the initiative, but restricting civil liberties should be a fairly high priority in communicating to people when they're voting on legislate or voting on initiatives in this case. So we should be clearly communicating that. And it's pretty significant. I mean, the trend has been since 1971, and the 26th Amendment was in the Constitution to increase to reduce voting age to 18 from 21. The trend has been in our country to extend the franchise of civil liberties to a younger age, at least to 18. And we're going in the reverse now with this initiative. Again, not arguing the merits, but we need to very clearly communicate that we're just going to say we want to deny those civil liberties now that they've enjoyed up until this point in time to that age category. And I think that it's important that we clearly communicate that in the language of the initiative. And I don't believe that the current title does that. And so I think that those are the two elements of omission that I would say from a priority standpoint that I think need to be clearly communicated in a concise statement.
Mr. Morgan?
Yes.
Do you believe that folks that have an interest in fewer firearms regulations would not be on notice that this initiative is of interest to them as written by the Attorney General's office?
I believe that it doesn't clearly communicate that. All it says here is impose age limitations. It's not clear that it's actually in total, I mean, it's an age prohibition, restriction on 18 to 21-year-old possession of commonly found firearms. What they're just saying is age limitations in here, and I just don't think that's an adequate, concise explanation as to what the initiative actually does. And I think being more specific and clear. Ballot titles typically integrate numbers that are introduced within, usually their taxes or something like that, where they're introducing, here's the percentage, here's the minimum wage percentage, here's the tax number that we have. And nowhere do we clearly say in this concise description what the age limitation actually is going to be on this. And I think that should be clearly spelled out in the concise statement if possible. And that's one of my arguments on just the omission. The other part, then the second part, going back to kind of sins of bias, there's two value-laden terms from a language standpoint that do create bias for or against the measure, which are currently integrated into the initiative. And you've heard earlier the discussion about enhanced. I do think that's a value-laden term that's being used in this initiative. And additional background checks, I think, would be appropriate, but I think enhanced is just the wrong word to use, and it's a value-laden term in the setting, in the context that's being presented here. As I think the previous for the attorney for the NRA mentioned earlier, that just because you put language in an initiative and you repeat it many times, it doesn't mean that language must translate to the title. It really has to be something that people can understand. And since from what I understand of these actual background checks, we're using the same NCIS database regardless. It's just an additional background check that you're doing. And additional seems like it would be a more neutral and accurate representation of what's actually done there. The other the value-laden term, I believe, is the term assault. So they are semi-automatic rifles. They are not necessarily semi-automatic assault rifles. Assault rifles is a value-laden term integrated into the language of this initiative to apply to commonly held firearms. In fact, some of the most commonly held firearms in Washington State and America today. And so I think that it's important that we just indicate that, to be more precise, it's a whole category, semi-automatic rifles, and they are being prohibited. And I think that that's a less value-laden term than adding the word assault in there. I think that the assault is a value-laden term and a term of art that's been used, poll-tested, and for political reasons. I understand why the sponsors would put it in there. But if language is to have any meaning, we need to preserve what it actually means, and I think that being more specific on that, I think, is important. The final element that I've argued, and I have not prevailed very often when I've been in the argument court, which is the tax versus fee argument. I think that the courts have trended over the years to disguise taxes and call them fees. There's reasons for that. Part of it's political. We don't call property tax a property home ownership fee. We don't call sales tax a purchase fee. We call these taxes. And then the argument here is that that in theory it's going to be dedicated to a certain administrative cost associated with the program, and that's been the argument they've had overall. I still believe these are taxes on ownership, and especially when we're applying a tax to something that's a fundamental civil right for somebody to have. We have to recognize this is still a civil right. The Second Amendment is still as much a part of the Constitution as the First Amendment is, or the Fourth, or the Fifth, or any others. And in the concise statement that I have there, I reference that as a new tax for sales and delivery of certain commonly held firearms. But if the court were to stick with fees at least it needs to be clearly spelled out in the concise statement that there's an increased cost associated now with purchasing firearms. I think that that's important. And with that, Your Honor, I think that's everything else I think I've laid out in both the briefs and the original petition. I'd be happy to answer any questions you have, or just reserve my time for a final rebuttal if that's possible.
Certainly.
Okay,
Thank you. Mr. Wilson.
Thank you. I'm Joe Wilson. I'm here pro se. I think I've laid out everything I'm going to say, in the briefs and in my reply. And so I'm just going to emphasize that in a little more detail. One thing that really concerns me is that we have this ballot title is supposed to be impartial. I mean, we have restrictions on words and it's supposed to be concise, but it's supposed to, I think the most important thing is that it's impartial. Some states allow where both sides can write the ballot title. In this state, the Attorney General does it. And this court and this challenge is where we have the opportunity to have all sides. And what we have here today is a ballot title that has been written by the Office of the Attorney General after, I believe, he endorsed the initiative. And to me, that puts a big cloud on this ballot title as far as being impartial. And I'm hoping today that we can remove that cloud, that we can create a ballot title that is not just using the words from the political campaign, but represents all parties. And in the eyes of the voters of this state, will see that it is impartial. And the reason that is so important is, like as I said, the National Conference of State Legislatures, they said that ballot titles are very important because a lot of people don't read the initiative. All they read is the ballot title. And this ballot title needs to represent what people are really voting on. Now, Benjamin Franklin once said about, if you give up liberty to have safety, you will end up with neither. And I believe what this initiative deals with is giving up liberty for what the political party is trying to say, safety. I think the initiative is poorly written, but the state Supreme Court, the state Constitution, preamble, we the people of the state of Washington, grateful to the supreme rule of the universe for liberties, do attain this Constitution. Well, why are we grateful? Because that supreme ruler gives us rights. Not the government, not even this court. And a political organization should not be able to take away those rights. So the people in this state, when they vote on this issue, they need to know that in this initiative, rights are being given up. Because if you read Article 1, Section 24 of our Constitution, it says that the right to bear arms shall not be impaired. And there was a court case in State versus Swanson in 2003, where the right to bear arms was construed as an individual right rather than a collective right. So individual rights will definitely be denied if this initiative passes of people between the ages of 18 and 21. If you deny them the ability to bear arms, because you are impairing that by that restriction in this initiative. And I believe we should have language in this ballot title that spells that out for the people in the state.
Mr. Wilson?
Yes.
I appreciate that you have very strong feelings on this issue, as do others in the courtroom. What I'm wondering about is this issue of notice. You were aware of this ballot initiative with enough time to be involved in this litigation.
Yes, to file a challenge.
And so, is it your understanding that people in your community who feel the same way that you do would not be on notice?
Well,
Really from an initiative that addresses the issue of firearms. If that's something that is so
Well-
important to them, wouldn't they be on notice?
The point is, as I told the court yesterday, I was wanting to do some polling. And I had my company in, so I couldn't get out of the office till that afternoon yesterday. So I went by one of the largest gun stores in the state in Skagit Arms at 4:30 yesterday afternoon. They had quite a few people buying weapons or looking at weapons, and also the employees. And I asked them, and it was particularly about the tax issue of this deal, of this initiative, that if they put where they charged you, $25 for every time you buy a certain weapon, would you look at that as a fee or a tax? And every one of the people in there said that it would be a tax. And you have to realize that, and what I found out in talking to the people there, and people are not really aware of what is in this initiative. They really haven't heard very much about it. I know that the people, the proponents of it, they have millions and millions of dollars. I know they will get their messages out. But I also believe it's very important that for the ballot title itself, that it is impartial, that it isn't just parroting what the proponents are saying, as the Attorney General has done in his ballot title, but it also spells out that the people of this state, what you're voting for is the removal of rights from some individuals in the state. I don't think there's anything more important than that. I think liberty is the most important. Our Constitution, our governments are here not to give us liberty, to protect our liberty. And if a group comes to this state and wants to take away the liberty of some of the members of the state, then that should be spelled out that that's what they're voting for, especially when we all know people are not going to read all these pages. I don't know how many pages. Like you said, it's a very complicated piece of proposed legislation. I think it's poorly written. I do believe with people's initiatives, what happened is that they do get rewritten if they do pass, but I think this particular one would definitely have litigation on constitutionality because of it.
Mr. Wilson, just getting back to my question.
Yes,
Perhaps it was poorly worded.
I'm sorry.
That's okay. But I'm just trying to understand the overall argument appears to be that the language doesn't put people on notice who have a strong belief regarding their Second Amendment rights, that this might restrict those. Getting back to my question, folks like yourselves that have that strong belief, wouldn't they know that from the language that was proposed by the Attorney General's office? In fact, wouldn't they know that solely by the subject of this initiative?
I don't want to assume what anybody knows. I think this ballot title should say what we're voting on. And we are voting to take away people's rights. I mean, 18 to 21 years old, they may not be a majority of the population, but if you look at the people who've died to give us the republic we have, there's been a heck of a lot of those people between 18 and 21 years old. I do believe strongly that if we do not mention that in the ballot title, the concise statement somewhere that individual rights are going to be impacted when you vote on this, then we're not presenting to the people the truth of what they're voting for. And right now, I think this whole process of the ballot title has a huge clout because I really believe the Attorney General, since he's already endorsed this initiative, is not partial. Is not impartial. He's partial, and he has used words from the actual campaign promoting it in the ballot title. Also about the tax. Like I said, I asked everybody at the gun store about the tax, and they all said they looked at it as a tax. But one thing you have to realize, $25 doesn't sound like a lot of money. But this initiative would put a tax on all semi-automatics. Now, 10.22s are semi-automatics. They shoot a 22 long rifle. I wanted to bring one of those bullets in here, but you'd probably put me in jail if I showed up with a bullet. But it's so small you can barely see it. No military in the world uses it. If a country did, they wouldn't survive very long. And yet, this gentleman wanted to call that an assault weapon. But those kind of guns only cost a little more than $100. So you put a $25 tax, that's a huge percentage of the cost. So it is a big thing. The tax is something that the people, the consumers, will feel impacted with. So I do feel like it should be mentioned that they're supplying the tax, and I do feel very strongly. This isn't about guns. This is about rights. This is about rights that was given to me that no government can take away from me, but yet I'm being asked to vote on it. And I think we should tell the people what they're really voting on. Thank you.
Ms. Ziegler, before I hear from you, I just want folks, please come forward, the folks in the courtroom to know I am doing other things. In fact, I am hopefully concluding about a 5-week trial, so the jury is deliberating at this time. So if you see things happening in the courtroom, that might be one reason why. I haven't heard from the jury, but they are deliberating today. So I don't want that to disrupt this argument at all, but I just wanted the parties to be aware of that. Ms. Ziegler.
Thank you, Your Honor. I want to start by explaining the role of the Attorney General's office. I think that would be helpful for those in the courtroom to understand. The Attorney General is an elected official who does declare a party, unlike a judge who does not. That has always been the case. And despite that, the Attorney General's office is charged with representing agency decisions, with defending the law, and with writing ballot titles. We're statutorily responsible for doing that. And in this particular case, the Attorney General did not direct how this ballot title was written. I don't know if he has endorsed this measure. He certainly has taken positions on gun control in the past, but he was not personally involved in this, and I have never received direct instruction from an Attorney General on the wording of a ballot title. That said, in all things, the Attorney General strives to comply with the law, and the law requires an unbiased ballot title be written. And the law also provides this court proceeding so that this court may allow individuals to object to the ballot title and make a decision about whether appropriate wording has been used. So due process has been protected. All individuals have been given an opportunity to object. And in fact, we have a hearty objection here from 4 different parties, which I think is an excellent demonstration that the system is working and that the court is provided with all viewpoints and an opportunity to assure that the voters are provided the unbiased ballot title that they are entitled to. That said, I want to turn to why I believe the Attorney General's office has provided an appropriately unbiased and complete ballot title. Starting with the statement of subject, I understand the concerns that the word restriction be included. However, that statement of subject has to be sufficiently broad to encompass every aspect of the initiative. This does more than restrict access to firearms. Most particularly, it also includes additional criminal provisions. When individuals' liberty in the community is at stake, a criminal provision is very important, and I think that it may well jeopardize the legality of the measure were it enacted to have a statement of subject that is too narrow to encompass that criminal provision. In addition, a narrow statement of subject as offered by the 3 parties would not include the fact that a fee would be permitted, not mandated, but allowed. 2 of the options included the word taxes. That, Your Honor, I understand that a citizen may not understand the difference between a tax and a fee, but there is considerable legal difference, as our state Supreme Court has held recently in the Watson case cited in the brief and in the long-standing Cobell case as well. Given the significance of that legal distinction, I'll let that objection stand with respect to all proposals to replace the word fee with the word tax throughout the proposals on the concise description and the statement of subject as well. Turning to the concise description, starting with the word enhance, The word enhance, as you have indicated, is the word used in the measure. We frequently try and stick to the measure's language to avoid restating the measure in a way that may be unbiased. The words additional or increase, I don't think that those would be outrageous changes to make, but I do believe the word enhance, which sticks to the measure's language, is the most accurate. The criminal provision that is included in the Attorney General's concise description, again, that concept, it is essential that it appear in the concise description. I think I am hearing agreement within the courtroom largely, if not by everyone, including by the NRA, that that needs to be included. I have no objection to the language that you have proposed, which I understand to be criminalize non-compliant storage upon unauthorized use. I think that is a fair description of the measure, and if we have room, that would be appropriate. The term age limitations, again, I believe that that is appropriate. I really don't follow the argument that the word restrictions would be more correct, or that somehow limitations would, if I understood oral argument correctly, indicate that those younger could obtain a gun. I don't think anyone would read it that way.
Do you sense a difference between the word limitation and restriction?
Honestly, I think it's negligible. I don't think that it's a major issue. I think limitation is accurate. I think in common parlance, that's how we think of, for example, the drinking age as a limitation on the drinking age. But I don't think restriction would be legally inaccurate or misleading to the voters. With respect to the fees, this does not impose fees. It allows fees to be imposed potentially. We cannot assume that that will be done. A fee cannot be imposed at all unless it's going to be dedicated to that use. I don't know what the department that is permitted to look at that and consider fees would decide to do. So we can't say that it's mandated. Including fees as something that could be done, certainly that's a provision that could have been included. There are other provisions that could have been included as well. For example, Section 15 allows, or rather requires, consideration of ongoing verification processes to determine whether people remain eligible to have a gun in their possession. There are prosecutorial provisions that would be put into place that allow the prosecutor some discretion. So there are, in this large initiative, many other provisions that we could not find room for in the concise description, and that is why the option of using a catch-all clause and enact other firearm requirements was used. Perhaps that catch-all could be shorter, and that could buy a word for the altered criminalization provision.
I'm interested in that because I'm looking for one more word, of course.
I have an option for one more word.
Okay. Well, in addition to one that I'm already contemplating, which is to delete the firearm safety phrase. But the question that I have is about that the very last phrase, and enact other firearm safety requirements. As you just indicated, there are other things in the initiative that aren't necessarily requirements even. For instance, you mentioned the prosecutorial discretion, other things like that that are included. Have you thought of some language that would be a better catch-all?
The key component there is that it is a catch-all because voters should be aware that there are other things that we weren't able to fit into the tiny, concise description we're permitted to write. Even if it said, and enact other provisions, I think it would be sufficient. So dropping the word firearm safety, I would have no objection. I just want to make sure that the voters are informed that if you are interested in this, you should go read the entire measure, because there are other things that we could not include because, of course, we have a statutory cap allowing us to include no more than 30 words after the first 3 words this measure would. And so for that reason, we are somewhat handcuffed in what we can do. And it's important to highlight to voters that there is more here. You may want to read this and see how it affects you.
And do you have a proposal to give us one more word in order to allow the court to insert two words, which would be something like allow fees or permit fees?
The one more word option that I can think of is taking the phrase impose age limitations, dropping it down to age limitation, and adding it after the word training. This measure would require enhanced background checks, comma, training, comma, age limitations, etc. And that would drop the word impose and find one more word for the court.
Thank you.
With respect to the summary, I think that the objections that have already been voiced stand in terms of our response to those. If we had additional space, the NRA's comment that there are restrictions on out-of-state purchasers in Section 12, I think that is a reasonable suggestion. We simply ran out of room for that. The sponsors are troubled by the inclusion of the age limitations. The reason that we included those is that those are currently in federal law, and now they would be stated in state law. And so that is a difference, and that's why we wanted to include that. There was also discussion of the term firearm training. I think that that term is appropriate. It does cover more broadly all of the elements of the initiative. So with that, Your Honor, I want to pause and ask whether you have any additional questions, any other way that I can give assistance to the court.
Thank you. I think we've covered the concise description. I have a question with regard to the summary, and it relates to one of the things you just mentioned, which was training. The firearm training is the word in there right now. I am concerned that sounds like firearm training, how to fire a firearm, and that doesn't seem to accurately describe the type of training. And as you've heard me say before, I'm not sure that safety training covers it, although it seems to be that might be closer to what the initiative calls for.
I don't think that it would jeopardize the legality or the breadth of the knowledge provided to the voters to change it to safety or even drop it to training. But some aspect, putting them on notice that training is addressed, is what needs to be there. I think that's the more essential point.
And second, on the summary, it seems to me that, again, mentioning the word firearm multiple times, it wouldn't necessarily be required. Folks should know at this point that we're talking about firearms. So, for instance, in the phrase, including prohibiting firearm purchases by persons under age 21, it would seem that folks already would know that we're talking about firearm purchases. And the reason I am looking at that is in order to add potentially the word administrative before fees, as has been proposed. I understand that's not remotely in agreement by all of the parties, but and then we have the issue of restriction versus limitation in the summary as well. So those are my inquiries about that.
So same concerns with respect to restriction versus limitation. With respect to the word in that phrase, prohibiting firearm purchases, the reason in that instance I think that it may be important to keep is that this adds to state law provisions relating not just to semi-automatic rifles. That's why I think the broader phrase might be necessary, so that we don't risk a voter assuming that those age restrictions would only affect in state law semi-automatic purchase or transfer. Adding the word administrative before fee, I don't think is necessary. A fee by its nature is administrative. It can only cover the cost of administering a particular program, so Legally, it doesn't add anything. Perhaps it has a slight nuanced meaning to voters. I don't think that it is significant, but I do think including firearm to alert the voter that this is an age restriction for all firearm purchases, not just semi-automatics, which are very heavily the focus of this initiative, may be of importance.
Let me ask you this with regard to that, and I appreciate your response. The phrase comes after the reference to certain firearms. So it says, it would impose age limitations on who may purchase or possess certain firearms, including prohibiting firearm purchases by persons under age 21. So that phrase says including when talking about certain firearms. So I'm confused as it's written.
I think, good point. That word, with respect to that sentence, it already is more broadly referring to firearms, that if you did drop the second firearm, it wouldn't be a loss, so I agree. And
I think it's actually an improvement, because otherwise it's talking about a narrow group and then it includes a larger group, which doesn't really make sense.
And if the goal is to include the word administrative, we don't have any objection to that.
Or there may be some other word that may be more important to put in. I don't know.
I'm not as concerned about the summary. I think that as written, that it is inclusive. If there is another single word that was found appropriate, do you have anything in mind that I should address?
Not necessarily. The only other thought I had, if we had an extra word, and I feel more inclined now to take out that word firearm, is to perhaps reference firearm safety training and utilize the word that way.
I think that would be a good option. Yes.
That's all I have.
All right. Thank you, Your Honor.
Thank you. So I will hear from the parties again. I've heard from everybody once. And I don't know if we need a break. We've been going for quite some time. So probably the clerk needs a break. I don't know. But before I hear from everybody again, I would like to make a proposal and hear from the parties regarding the court's proposal. The reason I like to do this is because sometimes, even having heard from the parties and having reviewed the briefs, I'm thinking of a proposal, and there's a good reason that we should not change it that way, but I haven't heard. And so I want to make sure that all of the parties have the opportunity to respond to the court's proposal before I make my final decision. And so a proposal that I would like to hear from the parties about concerns a change in the concise description. The change that I'm contemplating at this point would make the concise description read as follows. This measure would require increased background checks, comma, training, comma, age limitations, comma, and waiting periods for sales or delivery of semi-automatic assault rifles, semicolon. Criminalize non-compliant storage upon unauthorized use, semicolon. Allow fees, semicolon, and enact other provisions. The change that I am contemplating on the summary impacts two places. First, the first line where the court would insert the word safety after firearm, so that it would say firearm safety training on the first line. And then in the middle of the summary, the clause after certain firearms would say, including prohibiting purchases by persons under age 21. So those are the modifications that the court is contemplating at this time. Again, this is not the court's final decision. I'll hear from the parties again after a brief 10-minute break. Court being recessed.
Please rise.
Again, regarding the court's proposal for change in the concise description and summary. And so I'll do that. Mr. Brown?
Volunteering to go first has its consequences.
Indeed.
I'm happy to do it. Let me address just a few different issues, Your Honor. And I think as a starting point, the proposal by the court is acceptable in many ways to us, but we do have a few concerns. One, we still do think that enhanced is the preferred and appropriate term. And it's interesting listening to the arguments of the other parties. They've sort of stated that as a matter of fact, that enhanced is prejudicial or improper for some reason, without ever articulating the reasons why that it is prejudicial. Again, it is the term that is currently used in Washington state law. It is a term that is defined in a very neutral manner in the Webster's dictionary that the court relies on. And so we don't feel that simply stating that it's prejudicial has meant that really justified a reason to change it. If the court was to defer to increased, we would be okay with that and understand the reasons for it. But enhanced really does capture what the measure does, and so we would defer to that term. The primary concern that I have with the concise description, Your Honor, is the use of the term non-compliant. And we have concerns for a couple of different reasons. One, non-compliant, standing alone, is rather vague. It doesn't really say what you have to comply with, what sort of behavior might be criminalized by your non-compliance. And so we don't think that that actually provides voters with the proper notice that is required here. Second, in some ways, it's sort of redundant. You certainly don't criminalize compliant behavior. So saying criminalize non-compliant and then the following provisions doesn't really add much here. What we would suggest, as we put it in our brief, is use of the term unsecured. That is a term, or secure storage is defined in the initiative. It gives the voters some indication about the type of behavior that they need to comply with. But simply saying non-compliant doesn't really provide that notice, and it can be redundant with the other provisions that the court has suggested. The language around allowing fees is fine for us. Again, we don't think that would be the first way to do it, but we understand the court's priorities there. We also think that firearm safety gives the voters more indication about the other provisions that might follow. We understand that striking it might provide some more room and flexibility. Our preference would be to include it because it does provide additional information that won't otherwise be present by simply striking it. I want to turn, if I can, to the ballot vendor summary. And my primary concern there, one, we do think adding administrative fees and safety to the first provision is appropriate. But the way that the summary is currently drafted by the Attorney General in the second provision, starting with it would impose, that implies that this is imposing new requirements on firearms other than semi-automatic assault rifles. And that's simply not the case.
I'm sorry, where are you in the?
Sure, using the current AG's language, the second sentence starting with it may or would impose age limitations on who may purchase or possess certain firearms. That's inaccurate. The initiative solely addresses new requirements on semi-automatic assault rifles. Under state law, you have to comply with federal law, as state law that currently exists. Under federal law, you have to be 21 to possess a pistol and 18 for other provisions. The initiative itself only affects a change in current law with respect to semi-automatic assault rifles, which is why we suggested putting the age limitations language in the first provision, because certainly just referring to imposing age limitations on certain firearms implies that this new law has a broader effect than it actually does in fact. It's a small thing, but we do think it's important, and so we would suggest the court try to find language consistent with the sponsor's suggested language that makes the age limitation clear that it only applies to semi-automatic rifles. The last portion I want to address, although we agree with the court's language in using the term semi-automatic assault rifles, I'm sure that the other parties will take exception to that. Assault is important here. It's important for a few different reasons. Again, it's a commonly understood term. It's a term that has been used in federal law for over 20 years. It's a term that's been used in our state legislature for some time. It's a term that's been used in Washington state courts for some time. And it's a term that is commonly used in public discussions about these types of weapons. If you remove the word assault and simply have some of the other quote suggestions, you're not identifying for the voters why the specific type of weapon is being addressed in this initiative, and so we would encourage the court to keep that specific term in the initiative. Unless you have any other questions.
I just have one, and it really relates to a clarification that I wanted to make. During the break, I was looking at the summary, and it appeared that should the court make the changes proposed in the ballot title that your client disagrees with regarding the terms enhanced and unsecure, it would seem that those same changes should be made in the summary. I assume that your position is the same. So in other words, on the summary referencing increased background checks, I don't think I said that before, but I think that change should be made if the court makes a change to the ballot title from enhanced. And similarly, from non-compliant, if non-compliant is used in the ballot title, that word should be used in the summary. Similarly, if the court takes your position, the word unsecure would be substituted in both.
Correct. Yes, we would believe that is appropriate.
And your position is the same with regard to the summary as it is with the title?
Yes, sure.
Thank you.
Thank you, Your Honor. I'll be brief. We do appreciate the modifications that the court has proposed. We do have some further suggestions for you to consider, but we do appreciate what you've done. I guess working backwards, on the ballot measure summary, yes, we picked up the same thing. We would agree that, increased is better than enhanced, and that increase should be used in the ballot measure summary for the same reason that the court is contemplating making that change in concise description. Just briefly to address Mr. Brown, I think we have made it clear why we think that enhanced is inappropriate, and that is it is a value-laden, bias-heavy word. So we agree with the court on that. We agree with the court on non-compliant. Really, the only issue that we have on the ballot measure right now, the court is not modifying fees, right? You're just saying and fees. Am I right about that?
So the way I thought was allow fees, although, permit fees, authorize fees.
But I'm talking about on the ballot measure.
Oh, I'm
summary.
sorry.
Because I work backwards.
Right, the last
Sorry.
two words would be add and fees.
Okay. I would just put in a pitch for, and it seems, and you've added firearm safety training. I guess my only thing I would ask for the court to consider is, training has been modified, right? The training, the voters will know, it's about firearms. And I understand the court's issue about, well, maybe that's a little misleading, but they'll get that from the initiative. You're at least modifying what training is. Fees is not modified at all. And rather than taking another word to further modify training, firearm safety training, we think it would be more fair to modify fees to say, these are purchase fees, right? These are fees that would be imposed on the purchase of firearms. Just throw that out there for the court's consideration. It just to us, it seems like there's a potential imbalance there. On the concise description, we're largely satisfied with what the court has done. If we were to suggest anything, we think that you could strike or delivery, because again, we're in this world of a concise description. We only have 30 words. I don't think the fact that this applies, I think most folks would understand that delivery would be swept in with under sale, and that would give you the ability to modify fees to say purchase fees as we have suggested, and it would allow you to add firearms to training. Right now, training in that concise description is unmodified. I think that's a little, that could be, I guess if I'm a voter, I'd rather know what sort of training is in this thing as opposed to the fact that it covers not just sales or delivery. So to me, given that we only have 30 words, we're trying to sort of get the most bang for the buck out of these words that we can. I would at least consider striking or delivery and modifying fees and training in the way that I just said. And then I guess the final thing, I don't know if it's a lost cause yet on the subject, but we would continue to urge the court to adopt our subject for restrictions, firearm restrictions. Really, the only argument I heard was from the AG, who said, well, it doesn't cover everything. But of course, the imposition of fees, criminalization, those are classic instances of a restriction. Those are analyzed under a legal framework of restrictions on a constitutional right. And so again, we're not here to argue that, but I don't think it's a fair distinction to say, oh, well, wait, restrictions doesn't cover a fee that is imposed on the purchase of something that you have the right to purchase, or you don't think restriction covers criminalization. Those are hindrances, obstacles, impositions to your ability to do certain things. It is a restriction. So given the mandate that we all have here, which is to be both broad and precise, we do think, as the courts have done in the past, that the title should be involved in the use of the word restriction. And that's all I have unless the court has questions.
I do have a question about the potential of substituting the word unsecure for non-compliant. I had originally put in the word unsecure in order to keep the same number of words and describe what was, I thought, in the initiative. And then I was persuaded by Mr. Morgan's use of the word non-compliant, and I guess I'm coming back to this. As Mr. Brown indicated, he went first, so he's not going to have an opportunity to come back again. So I want to just address that concern that non-compliant may be unnecessary, because obviously if there were criminal penalties, it would be non-compliant.
I'm not so sure about that. I was thinking about that. I mean, I think we do support non-compliant. I was thinking about, Mr. Brown made a good point there about like, well, what is that? But there aren't there types of criminal regulation where it doesn't matter what you do, it's just strict liability type stuff, right? Like where it's just, you can't do a certain thing, it's just a flat out restriction. And here we're talking about something where, I guess the signal, I think, and the reason I guess we support that is you're signaling that there are some things you could do to comply, and if you don't, it's a trigger, part of the fun. It's to go look into to look further at the initiative to find out what is compliant and what's not compliant. So I think that it signals that, right, to a potential voter that they should look at that.
Let me ask you a different way, because the term secure is in the initiative numerous times to describe the particulars of storage or leaving a firearm or whatever. Is unsecure, do you think, in any way a biased term?
I really don't. I don't have. I won't say that. I don't have the same reaction to it that I have to some of the other words. So I don't have a strong reaction to that as being a biased word. I think that non-compliant works better, but I don't have. It doesn't affect it, simply enhance. So let's move that way.
Thank you.
Okay, thank you.
Mr. Morgan.
Your Honor, just to, maybe I'll start with a statement of subject and work backwards down if that's possible. I still, I provided in my original brief a couple of options on concise statements, and I think the second one, if the court doesn't want to use the word taxes, if that could be replaced with fees, at least I believe the second one was sufficiently broad and specific enough that it would be better than just saying generically firearms. So I'll still rest on that argument. With the proposed changes on the concise statement, I generally view those proposed changes as improvements over what was presented here earlier, I do think increased is a more accurate and less value-laden term for compared to enhanced. So I think that's a good improvement, and I appreciate the court's looking at a non-compliant, and I'll make an argument in favor of non-compliant if I can. The initiative itself doesn't really provide a lot of clarity as to what this is going to end up being, and unfortunately we're probably going to have lots of litigation to determine what's defined as secure or unsecure under what settings. And I think that non-compliant is a more accurate term, because whatever this ends up sorting itself out, because unfortunately the initiative doesn't really explain that very well. I think that's a better word for voters to realize this is going to be a fairly significant impact, very significant if it affects you personally. And I think that's better than saying certainly it's a substantial improvement over certain. And the court's suggestion upon unauthorized use, I think is very good. I think that's also a good improvement. Allowing fees, again, despite my concern about taxes, that's still an improvement as well. And I also appreciate the age limitations that the court suggested as well. I think that's, again, very important to add that in so that people are aware of that within the concise statement, since that is quite a significant change. I do still believe the term assault, as much as it might be defined, I still think it's a value-laden term that's being integrated in here. I would oppose it with its use here or in the summary in both cases. I might make a suggestion that
The term criminalize, is that what you were saying? I'm
no,
sorry.
assault. I apologize.
assault, I'm sorry.
Yes, sir. Yes. So it'd be the assault that I was. I've argued that that's a value-laden term, and I would stick with that. But generally, I think that the court's suggestions are an improvement over what it is now, and sometimes that just getting an improvement is a step in the right direction. On the summary, I think the change that we make in the concise statement trickle down to the summary. And so I think that I'd just be repeating myself to go through what those would be. So with that, I generally, other than the term assault, I think that the proposed, where it's especially increased, is a good improvement in there. And I appreciate the court's willingness to listen to us today. So thank you very much.
Thank you. Mr. Wilson.
I think, I've made my opinion pretty well expressed. The Attorney General, because of its extraordinary move to endorse this initiative prior to supposedly being, contributing to an impartial ballot title, I think does put a cloud on it. And even though the Attorney General's office says that the employees there did it and not the Attorney General, I know that if I'm working for somebody and he wants a certain thing and I want to keep my job, I'm going to be influenced by that opinion. Therefore, this ballot title has a cloud because of what the Attorney General's done. And just to change a few words in it, to me, does not remove that cloud. And as I mentioned, it's a lot of political statements in here. The assault weapons. All semi-automatic rifles are not assault weapons. They're not used by militaries. There are some calibers that are, and there are some that are not. It's strictly a political statement, and will be part of their campaign. They will spend a lot of money beating that drum. I don't believe to have an impartial ballot title, that language should be in there. I would love to see that the individual rights issue mentioned, because this is going to deny more than just our Second Amendment rights or our Article 1, Section 24 rights under the Washington Constitution about the right to bear arms not being impaired. This also goes into a 3rd, 4th, 5th, and 9th Amendment of the U.S. Constitution. There's things in this initiative that are not very well explained. I mean, one about if somebody owns a semi-automatic weapon, then the sheriff's going to have the ability to monitor whether they can keep it. You give up your rights, your HIPAA rights, where they can go to your doctor to find out your mental state. I think the biggest problem we have in this country today is that we try to solve problems based on those that are irresponsible by punishing the responsible. This initiative will affect a lot of law-abiding people They have not committed any crimes, never intend to commit any crimes, but yet make felons out of them. That doesn't solve the problem we want to solve. As I said, I think Ben Franklin had it right. If we give up liberty for safety, we're going to end up with neither. We need both. We need liberty and we need safety. Thank you.
Thank you very much. Ms. Ziegler.
Yes, Your Honor, I think that you have offered a reasonable adjustment. I do think the word unsecure, if it's not objectionable to the NRA, as they have represented, would be a reasonable substitution. That is a defined term in section 16, sub 24. So like the term semi-automatic assault rifle, it does have a definition within the initiative, so it wouldn't just be a free-floating term that one might consider biased.
I have a question about that.
Yes.
In utilizing that term, it takes away the word certain.
As I understood it, Mr. Brown was stating that it would be a direct substitute for the word non-compliant.
Right, and the court had proposed substituting non-compliant for certain. And so substituting unsecure now would take away certain. And so I just...
That is a good point, because not all unsecured as defined storage would result in a criminal prosecution. So the term non-compliant would probably be more precise there. So I'm going to back up on what I just said and say that non-compliant may be the better choice.
I mean, I'm not sure, I'm just sort of...
Right, but I'm trying to think through the definition of looking at both the criminal provisions and the definition. Not all failures to secure in the manner mandated by the initiative would result in a criminal sanction, even if there was unauthorized use.
But just to play devil's advocate,
Right.
as we're sort of playing with this, using the word criminalize doesn't necessarily connote a criminal prosecution would occur in every case.
No, it doesn't, but not everything would be criminalized. Not everything would be a Class C felony. So you could have unsecured storage that doesn't result in the option even of charging a crime. So,
I'm just kind of going back to that word criminalize, though, doesn't necessarily mean an automatic criminal penalty.
correct. But when one is under the cloud of the potential for a criminal sanction, I think that's a very extreme measure that the voters should be aware of. And that your actions, the actions of those who are current gun owners may be engaged in storage in a way that would become criminalized, could put them at risk of being charged with something. I think that word is necessary to put them on notice that they need to see. Are they currently doing something that would become potentially illegal?
So the Attorney General would be opposed to the word unsecure substituting for non-compliant without the word certain. Is that what I'm understanding? You can think about that.
Yeah, I do need a minute to think
And
about
maybe
that. It's not
everybody
something I
needs a
want to flippantly say.
And I see Mr. Brown's thinking about that too, so I'll just sit on that for a while and we'll go on.
Okay. One of the other comments that was made was the potential to drop the word delivery. I would strongly oppose that. Delivery is an important term. It covers transfers and not, so this measure doesn't just address sales by gun dealers, but gun dealers also play an important role in transfers between people who aren't actually selling, and that needs to be conveyed. That's why the word delivery is used constantly throughout this initiative, often in conjunction with the word sale, to say sale or delivery. They are different terms, they have different meaning, and they will signal different things to gun owners who may want to transfer a weapon to a friend or a family member, etc. And then the summary argument with regard to the age provision, again, counsel is correct, Mr. Brown's correct, that the current age provisions in federal law, which are incorporated into state law, are not altered. The change is this now brings age restrictions into state law so that if the federal provisions change, I think the state provisions would stand at this limitation as opposed to continuing forward with the change in the federal legislation. Considering how volatile the topic of gun control is in this country right now, I think that it is important to let people know that there would be changes in the state law. And the reason that that phrase in the summary is so long is that there would be a variety of changes. It's not a flat change to age 21. There are also transfers that could occur between those ages 18 to 21. So it would affect 19 and 20-year-olds differently in some respects, and that's why the two phrases referring to the age restriction. It's pretty complicated the way that this would amend the law.
Is the Attorney General in support of the phrase as the court has proposed it?
Yes. And with that, I would like just a minute to consider that provision of non-compliant and unsecured. It's okay if I can sit down and
Certainly.
go through and give you an answer with certainty.
Certainly. And I'll let the other parties weigh in on this as well. I'll tell the parties that the court has largely come to its ruling, but I do want to hear from the parties with regard to the substitution of the word unsecure for the wording of non-compliant that the court had previously proposed. It appears to me that that might require another word, but I'll hear from the parties regarding that particular point, Mr. Brown.
Your Honor, to begin with, I think it would be helpful, at least for me, could you just restate the whole phrase that the court has suggested, starting with criminalize? Criminalize non-compliant?
Yes. So the phrase is that I had previously proposed, criminalize non-compliant storage upon unauthorized use. What I was leaning toward was criminalize unsecure storage upon unauthorized use.
So the word number doesn't change with that?
It doesn't, but as I was speaking with Ms. Eagler, we sort of came to an understanding that that might create an issue because it takes out the word that was in the Attorney General's original language of certain. When we talk about non-compliant, it doesn't, that word tells people that certain storage is okay and certain storage is not okay. But if it's non-compliant, it's included. Unsecure, I'm concerned, may or may not, I mean, I'm unsettled, but without the term certain unsecure storage upon unauthorized use may be more accurate. And I don't know, I'm unsettled on this, but I wanted the parties to have an opportunity to address that.
It's more art than science. Well, first of all, we had actually suggested unsecured with the D. Might not make a major difference here, but I think because the definitions that are at the end of the initiative define secure gun storage, and what, if you're not complying with that definition, then you would be unsecured. I don't necessarily think that you need the word certain to clarify what those circumstances might be. Again, non-compliant from our perspective is a vague term and redundant, as I stated previously, that if it's criminal, you're not complying with the law, and so criminalizing non-compliant to me doesn't add much for the voters, whereas we have a definition of secure gun storage that provides the voters notice of the type of storage that would be required and the type of circumstances that might lead to criminal prosecution. The court did correctly highlight that criminalize is always optional at the discretion of the prosecutor and the circumstances that might present in any given case. So I think that because secure is a term that's defined, it is certainly much more specific than non-compliant. that will give voters the best direction about what the initiative entails.
So it appears that secure gun storage is defined, but unsecured is not necessarily defined.
It's not a standalone term, and I think it follows from the definition of secure gun storage, but unsecured itself is not separately defined here.
And it appears that, correct me if I'm wrong here, but that criminal penalties may result from a firearm not being secured in a way as defined by the initiative, but in addition being left in a place where others could access it. So
Right, it's a multi-part. I mean, it's not, the simple act of not having a firearm secured is not a crime under this. It's a crime if it's unsecured with the definition, and it results in unauthorized use by a prohibited person. So you have to have two components to actually result in criminal penalties, not simply having a weapon unsecured.
So, Mr. Brown, your client would approve of the word unsecured with no other language as a substitute for non-compliant, is that correct?
Correct, John.
Thank you. Mr. Palmer.
Thank you, Your Honor. I think what we're struggling with is that this is complicated in the initiative, right? And yet we have these very small number of words to be able to describe it. So that's why we think non-compliant is better, because it flags for the voter. There are a whole bunch of restrictions and definitions and things in the initiative that if you care about, you should take a look at that, right? Like there is there is a way to comply, there's a way not to comply. And it is a signal to the voter to take a closer look at this in a way that I don't think unsecured is, right? I think unsecured, there's some people who think, oh, well, I know what that means, right? And I do think I would agree with where you're going with the singular. I do think you have to modify that with certain. I think really for it to be completely accurate, I think you would. So it sort of has two problems. I mean, it has the problem of it's two words, we'd rather have one. And I do think it's a little bit more misleading than simply saying non-compliant, which just suggests that like there are some restrictions and there's a scheme that's in the initiative, and you should take a look at that. So that's why we would support non-compliant.
Thank you.
Thanks.
Mr. Morgan.
I'll be brief, because this word, I think it was introduced in one of my, or a version of it, I actually originally said uncompliant, but non-compliant is better use of that term, was introduced in my original concise statement. And I would, the reason why I thought that was a better term, and as this discussion that we've had here has been, is because there is some lack of clarity as to what compliant storage and non-compliant storage is going to be in this case, and we really want to make sure people look at this a little bit more. And unsecured and secure is going to be very questionable, and as I think the AG mentioned, there's going to be situations where unsecured storage is going to be just fine, and so at least it won't be criminalized, let's just say. So I think non-compliant is the best term for the court to use in this case, and I appreciate the court looking at that as an option. I don't need to belabor that point, but thank you.
Thank you.
As I've said earlier, I think the initiative is poorly written, and there's a lot of things that needs to be defined. This area is one of them, because it talks about in your possession. So if I'm at home at night and I want to protect my family, how do I have, and I'm in bed asleep, how is my weapon in my possession? Do I have to have it under my pillow? You know, it doesn't define. So if I have it in a desk nearby where I can reach it, then is that compliant? So I think the non-compliance is definitely relative to how this initiative is poorly written and poorly defined, the restrictions given to the government. Thank you.
Thank you.
Honor, if we could look at the language together of Section 5. He talks in Section 1 about a person who leaves a firearm in a location where they know a prohibited person may gain access, and then has the sub-provisions, which in those sub-provisions, it doesn't say unsafe or unsecure. I mean, unsecure, it says unsafe storage. Unsafe storage is not defined, and I think that your original terminology would be better if we're going to drop the word certain as well, because we do have an undefined term, unsafe storage, and we do have some ambiguity introduced without the word security in particular by Section 6, which talks about trigger locks as a safety device. So it's unclear from this whether just being unsecure in the sense of the definitional term secure, which means locked box, safe, or space, is what is meant by unsafe storage, or does unsafe storage also include the component of a trigger lock being a potential safety device? So I think that your original verbiage would be more accurate, more informative to voters, since we have to drop the word certain. Thank you.
The court is prepared to rule at this time regarding this ballot title. Before I do that, I just want to mention to the folks before me that it's been a pleasure to be involved in this litigation. I don't always say that, but it truly has. I feel that this work in particular is the type of work that makes me proud to be a judge in this county. And I often have the privilege of addressing concerns of folks who represent themselves, attorneys in our community and throughout the state that are very, very excellent advocates. And today was no exception. Throughout the briefing in this particular case, as well as the argument today, those before me, whether attorneys or not, have been extremely articulate, professional, and courteous toward the court and toward opposing parties. And it is truly the best type of cases that the court has, because as I indicated, that is not always the case in this courtroom. And so I appreciate that folks can be extremely excellent advocates for their clients or themselves in their positions and still be articulate, professional, understand the legal standard, and apply it as best they can. And so I very much appreciate the work of everyone in this case. The Attorney General has a role in ballot titles, just like the court has a role. I believe that the Attorney General does its best, and I refer to the Attorney General as an office, that the Attorney General does its best to provide a ballot title that is neutral, and it has done so in this case. It often occurs that after a ballot title is formulated that other folks with interest come forward with other alternatives. And I appreciate the Attorney General considering those alternatives. It is the court's role to ensure that the language in the ballot title, in the summary, and in the initial initiative measure language, that it is neutral. And sometimes it's not easy to know whether language is neutral or not, because that neutrality is recognized in light of folks who have strong feelings one way or the other. And so it's important to have a process like this where people have the opportunity to say, I know that seems neutral, but it's not for this reason. So given all of those things, the court has found that some of the language that was initially included in the title isn't as neutral as it should be. And I mean no disrespect to the Attorney General in formulating this ballot title. Again, I think this is a very helpful process that we go through. before the initiative goes to the next process. And so the court at this time is ordering the modification that we have been talking about. The ballot title will read as follows. Initiative measure number 1639 concerns firearms. This measure would require increased background checks, training, age limitations, and waiting periods for sales or delivery of semi-automatic assault rifles, criminalize non-compliant storage upon unauthorized use, allow fees, and enact other provisions. The ballot measure summary will read as follows. This measure would require increased background checks, firearm safety training, and waiting periods before semi-automatic assault rifles may be purchased or delivered. It would impose age restrictions, limitations on who may purchase or possess certain firearms, including prohibiting purchases by persons under age 21. It would require certain certain secured firearm storage or trigger locks and criminalize non-compliant firearm storage if it results in unauthorized use. It would enact other firearm-related requirements, including certain warnings, record keeping, and fees. Do any council or parties require any clarification of the court's ruling today?
Your Honor, does the court anticipate putting out a written order today, or?
I am. I have prepared one. It requires a couple of changes, which will just take a few minutes.
Sir, thank you.
We require no clarification, and I guess we mirror the court's comments. We really appreciate the way the court has handled this and the time it's taken and the care, and it is a nice thing to be a part of, so we appreciate it.
I understand, and we'll stay around, is that correct, and wait, and then we can sign the order? Is that how that works? Okay.
Indeed.
Okay, thank you very much. It's much better than some of the other litigation I'm involved in.
I need no clarification. I'm not satisfied with what's happened, but I understand what you've done. Thank you.
Thank you. I will take just a brief recess to make modification, and the final order will read as I orally ruled. I just need to make some changes. I'll be back in a few minutes.
Please rise.